Mr Acting Deputy President, and at the outset, if I can congratulate you on your contribution to this debate. I thought you gave an outstanding speech, heartfelt, and the work you've done in remote and regional Aboriginal communities provides such a strong sense of integrity to the arguments which you put. So I congratulate you on it. It was a privilege to be in the chamber when you gave that speech. One of my most cherished possessions is an Aboriginal carving that was given to my grandfather when he was only 4 years old. And my grandfather grew up in northern New South Wales at a time when there was great segregation between Aboriginal Torres Strait Islander people and white Australians. And this Aboriginal carving was given to my grandfather by the father of a little boy, Aboriginal boy, who used to play with on the farm. And the father used to come to the farm with his son, and the two little boys used to play together. And the Aboriginal father of that little boy was so moved by the fact that his son and my grandfather could just play together, common humanity, playing together regardless of race, that he gifted my grandfather this beautiful Aboriginal carving, which is in my parliamentary office today. And it was something which my grandfather always cherished. And that represents the Australia I want to live in. That's the Australia I believe in, where we are together. And I fear that the insertion of a new chapter in our Constitution, which is different from all the other chapters in our Constitution, is a departure from that fundamental principle that we should be together. If you look at our Constitution, there's a chapter on the House of Representatives, there's a chapter on the Senate, on executive government, on courts. Each and every one of those institutions is open to full participation by all Australians, regardless of their ethnicity, regardless of their race, regardless of when they became Australian citizens. Everyone is equal in each and every one of those institutions. And now we have before us the proposition to insert a new chapter into our Constitution, which is something fundamentally different. Fundamentally different. And I simply cannot support it. One of the reasons why I will, in addition to not supporting the referendum question, but also will be campaigning against it, is the courage and the example which has been shown by people such as Senator Nampijinpa Price and also my good friend and colleague Senator Liddell, and people of the stature of Warren Mundine. I heard Warren Mundine give an interview recently when he referred to the fact that had been called an Uncle Tom by members of his community who disagreed, or members of the Australian community who disagreed with his position on the Voice. And it brought into my memory one of my heroes, Neville Bonner, the first Aboriginal and Torres Strait Islander person to be elected to this parliament under that chapter of the Constitution, establishing a Senate open to all Australians. And Neville Bonner suffered the same indignity, the same insults for being his own person and standing up for his own beliefs. Back in 2003, I made a submission to the Australian Electoral Commission that there actually be a federal seat named after Neville Bonner. And in that submission I wrote this: Neville had every right to be bitter, angry and disillusioned with his country, but instead of being eaten up by such justified emotions, he rose above it and sought and attained elected office whilst maintaining his grace and dignity at all times. Has any Australian who has obtained a seat in the Senate since Federation achieved as much simply by being elected? Mr Acting Deputy President, if I could give up my place in the Senate for this contribution, for this speech, if it were possible for me to leave this chamber and for Neville Bonner to take my place and make this contribution, I would surely do it. I would surely do it. And I must say, before I made my contribution in the party room on this debate, I went back and watched some of Neville Bonner's speeches to try and discern what he would make of all this. But I would so dearly love for him to make a contribution to this debate at this time. But it's simply not possible. So my first objection is one of deep principle. I believe that every single institution established by our Constitution should be open to equal participation by every single Australian, regardless of race, ethnicity, sex, gender, religion, whether they became an Australian citizen last week or whether or not they're a descendant of the longest continuing culture in the world's history. That is my view, and it is one of principle. My second deep concern with respect to the voice, a constitutionally enshrined voice, is whether or not it will actually reflect the diversity of opinions amongst Aboriginal and Torres Strait Islander people. And I sit in this place, and I've sat in this place for 4 years, and I've heard the wonderful contributions of senators from across the chamber, including our senators of Aboriginal heritage, including Senator McCarthy. And I've listened to Senator McCarthy, Senator Dodson, Senator Stewart, Senator Cox, Senator Thorpe, my own colleague Senator Nampijinpa-Price and Senator Liddell. They all have different perspectives, different philosophies, different ideas, different perspectives. How could they possibly be reflected in one institution called The Voice? There are many voices, many perspectives, many philosophies, and there is absolutely no detail provided as to how that diversity of opinion would be reflected through the institution which is proposed. And what do we have in the context of detail? We have a bill of 303 words. That's it, 303 words in relation to making a radical constitutional change. That is all the Australian government is giving the people of Australia to assess in the course of this debate, 303 words. And in that context, we have had evidence from very eminent lawyers who have raised deep concerns with respect to the risks associated with a constitutionally enshrined voice to Parliament and to the executive government. And in this respect, I note at the outset that the Langton Karma report, the Indigenous Voice co-design process, originally said in section 2.9, the design also reflects the need to respect parliamentary sovereignty and avoid causing unintended consequences. As a result, all elements would be non-justiciable. What happened to that commitment, that all elements would be non-justiciable? Rejected, abandoned. In the Liberal members' dissenting report, in the advisory report on the constitutional alteration Aboriginal and Torres Strait Islander Voice 2023, they raised a number of concerns, and I commend Keith Wallahan MP with respect to his contribution to this debate. And let it be known, let it be reflected on, 6 weeks they had to prepare this report with respect to a constitutional change. 6 weeks. And the risks they raised are obvious ones. If you have a constitutional right to make representations, surely the corollary of that must necessarily be the Parliament and Executive Government has a duty to, at the very least, consult and to consider. It necessarily follows. How can it not follow? How can it not follow? And there are eminent lawyers who have actually made those representations in the course of this consideration and debate. The first I'd like to refer to is one of the titans of the legal world in terms of constitutional law, who passed away this year on 15 May 2023, Mr David Jackson KC of my home state of Queensland. Mr Jackson served as a federal court judge. He was involved in hundreds of constitutional cases, renowned in the legal community as one of Australia's leading constitutional experts. And what did he say about the voice? The first observation he made in paragraph 11 of his submission to the committee was that the power already existed. But as he said, the short fact is that there is no reason at all why the parliament cannot now legislate to establish a body which has features similar to those proposed for the voice in proposed section 129. Nothing stopping it. Nothing at all. Secondly, as he said at paragraph 23, there is also a second aspect, albeit having some relation to the first. The inclusion of the proposed section 129 would mean that we become a nation where, whenever we or our ancestors first came to this country, we are not all equal." End quote. And that is the question of the equal civic rights. And those were the 2 points made by David Jackson. And those points were also supported by Ian Callanan, another eminent legal figure from my home state of Queensland, who talked about the context of legal action being taken around that duty to consider and duty to consult. And if people think this is made up, and the term was used earlier in the debate, gaslighting, as if this is misinformation, I refer people to the case of Love and the Commonwealth of Australia and Toms and the Commonwealth of Australia. All you need to do is read the first paragraph. You do not have to be a legal scholar to understand the legal risks associated with the model that's proposed here. In the first paragraph, Her Honour Susan Kiefel, Chief Justice, said that in this case, where the plaintiffs were arguing that as non-citizens, people who had been resident in this country and had the opportunity to become residents but chose not to, who argued that the power of the Commonwealth with respect to naturalisation and aliens should be read so as not to apply to a person who is not a citizen of Australia, but who is a citizen of a foreign country and is not naturalised as an Australian citizen, but who is an Aboriginal person. That was the argument. That was the argument, that the Commonwealth did not have the power with respect to deportation of an Aboriginal person, even if they were not born in this country, were not a citizen of this country. And this is what Her Honour said, the first paragraph. The plaintiffs contend that section 51, subparagraph 19, is subject to an unexpressed limitation or exception. An unexpressed limitation or exception. Now, Her Honour was not prepared to find such an unexpressed limitation or exception. Neither was Justice Patrick Keane from my home state of Queensland. Neither was Justice Gagala, ex-Solicitor General of Australia. But the other four High Court judges were. They found an unexpressed limitation or exception existed in our Constitution. Something which had not been identified for over 100 years was read into the Constitution. And that is the legal risk. That is the legal risk. And it is heightened. It is heightened by the fact that there have been a number of proposals to address this risk, and they have all been rejected. Why? Why are these proposals being rejected? The first, that there should actually be a qualification to subsection 3 of the proposed amendment, so that the subject of legal review would be the subject of this parliament to determine. Rejected. The second, that the second limb, subsection 2 of the proposed referendum, was unnecessary and could be omitted. Rejected. Father Frank Brennan proposed a change such that representation should only be able to be made to ministers as opposed to the rest of executive government. Rejected. All of those qualifications were rejected. Why? Why? Why were those proposals rejected? And that is the risk, that is the legal risk associated with this referendum. And when you combine that legal risk with the fact that there have only been 8 referenda passed in Australia's constitutional history, and none of them have been reversed, you will understand why there is a considerable proportion of this country who are already indicating that they will be voting no. There is a fundamental difference from the referendum in 1967, and that is one of the reasons why. The lack of detail, the legal risk and the permanency. And those who are putting forward this model have refused at every juncture to compromise with respect to the wording. And I deeply fear that there is a tragedy unfolding in Australia this year, and it is a great, great tragedy.
Thank you, Senator Scarse. Senator McKim.
Thank you,